Um, Hi, everybody. It's nice to see you all. Some of you I know, and some of you I don't. So I'm going to go ahead and introduce myself to start with. You are here for a short training on a couple of different statutes and legal requirements now that you're a member of the Produced Water Consortium. My name is Kyle Davenport. I'm an assistant solicitor general and senior assistant attorney general at the Colorado Attorney General's office. Pursuant to statute, the Colorado Attorney General's office is the law firm for the Produced Water Consortium. And I have been tasked since the creation of the Produced Water Consortium to represent you and the other members of the consortium, as well as
Kyle,
the entity as a
just a
whole.
second. Corbett, it says you are in a practice session. Do you know what that means?
I'm pretty sure it just means it's not like an official webinar, but we can still record and do everything. I'll just start it, probably.
It has to be an official webinar because more than one consortium member is at this meeting. So the public has to be able to log in.
I gotcha. Should be good to go now.
Yeah, that went away from my screen.
And are we recording again?
Yep.
Thank you.
All right. Good catch, Hope. Thank you. So, as I said, I'm an attorney at the Colorado Attorney General's office. Most of my time is spent representing the Energy and Carbon Management Commission. I've been at the AG's office since 2015, where I have always represented the ECMC, which was COGCC when I started there. So that's a little introduction about who I am. The next thing is I'm going to jump right into my presentation. If you have seen really any presentation from an attorney in my office about the requirements of open meetings law or Cora, this is going to look really familiar. Can everybody see my screen? Okay, so you should see a slide that's titled Overview right now. This is a real quick summary of the topics that I'm planning on covering today with you. We have this set aside for an hour, I believe. I sincerely hope that I will only take up about half of that time. But please interrupt me and ask questions as we go. So there's what we're going to cover. My guess is we're going to spend most of our time on the first topic, that being open meetings law and executive session, because that, at least to me, is at least the last time we did this training, that's where most of the questions came up. And also, I think that's just the least clear of the topics in terms of what the legal requirements are up there. And I'll remind everybody, we are in a public session. Um, if you have a question that you would like to ask, not in a public session, you are welcome to give me a call, send me an email, and we'll set up a time to talk. As we will cover in a minute, two of you cannot talk to me at the same time to receive that legal advice unless we are actually in executive session. So, with that intro, we will go into open meetings law. Open meetings law is the Colorado statute that requires all state agencies and local government bodies to meet and make decisions in public. Here is the general statutory citation. It's also quotes the beginning of the statute that states why the legislature adopted this law. And fundamentally, most of the case law, which are where courts is reviewing specific facts and provisions of open meetings law, provide that the fundamental purpose of it is so that the public can see how you make decisions, how state agencies and local government bodies make decisions. Okay. So fundamentally, any meeting of yours has to be held in public. And open meetings law defines what constitutes a meeting, and the statutory citation as well as a quote is there. And this, unfortunately, is where probably and I'll use the legal term squishy here. The squishiest of the legal requirements comes into play. This is this public business is sort of the operative language, the most important requirement for open meetings law. And perhaps not surprisingly, if you look at statutes common a lot, you will not be surprised to hear that that's not actually defined by the statute, what constitutes public business. So we have to look at case law to determine when you have to meet, what kind of conversations you can have that have to happen in a public meeting. And you are covered by open meetings law because the consortium fits within the definition of a state public body. And for state public bodies, two or more people are covered by open meetings law. That means if anybody on the consortium talks to anybody else on the consortium about the business of the consortium, that conversation has to be held in public and with prior notice to the public so that they can attend and at least listen in on that conversation. Local public bodies have a slightly less stringent requirement. So, how do we decide, is this a conversation that has to happen in public with the public able to listen in? Well, looking at case law and trying to figure out how we put guardrails on this, certainly where public business is being discussed, and we try to figure out what that means by looking at case law. But we know for sure that anytime official action is being taken, it has to be in public. We also know for sure that if a majority of the consortium or a quorum is present, it has to be in public. Uh, Social gatherings are excluded from that. They mean meeting in public with a majority of the board or a quorum to discuss official business or to take official action. Social gatherings do not have to be held in public with the public to listen in. As I said, notice is required. We have to give the public advance notice that a meeting is happening. This is a quote from, oops, sorry, maybe the clearest quote that I have been able to find, and it's not exactly clear as to what constitutes public business. Certainly discussions of a pending decision of the consortium, calling up another consortium member and saying, hey, how are you going to vote on this next week? Is not a conversation you can have in private. It must be held in public about how we're going to vote or how you're going to vote on something. If there is a link between the conversation that you're having and the job of the consortium, discussions about what kind of decisions the consortium should make, discussions about maybe something that happened at the last consortium meeting, those kind of things likely need to be in public session, and you can't have those type of discussions between two consortium members in private. I'll stop here. We can all think of hypotheticals that maybe make a decision difficult, or something may have come up in your own mind already about, well, should I have this conversation or not? I think the best course of action is if you are concerned that you're about to have a conversation with another member of the consortium that may be an issue under open meetings law, contact me before you have that. It's really hard in this subject area to set a series of guidelines or rules that can give you the answer to this question in all scenarios. And I recognize that many of you actually may talk to each other in the course of your day jobs, and there may be some bleeding into produced water or whatever it is. I am not saying you have to stop doing your day job to avoid violating open meetings law. Continue to do your day job. Have the conversations as you would in your job. Don't call another consortium member to talk about consortium activities. Other than that, if you run across a consortium member in a social gathering or happen to have a phone call with someone on what, or a conference call in which there's a consortium member, generally try to avoid discussing consortium business or avoid discussing consortium business. If it gets any more specific than that, probably the best thing to do is just to contact me and we can talk through the specifics outside of a public meeting. You and I can talk one-on-one without it having to be in public. Um, that again gives a little bit more about the policy. Social gatherings, again, don't apply, but let's not rely too heavily on these exceptions. Just because it may be a social gathering does not mean that you can still discuss consortium business. It applies to everything, any communication that you have at all. Text messages between consortium members in which public business is discussed are still considered a meeting. We'll get to core in a second, but the documents you create as a consortium member are public documents. They are subject to Colorado Open Records Act requests. So it may make some sense for you to somehow separate out the emails that you have pursuant to your consortium member business from your day-to-day life. I know that we have had consortium members or even ECMC commissioners back when it was when it was a volunteer commission, just create a separate Gmail account or some other type of free email account for that business. So they don't have to worry about, should we get a core request, searching through their personal emails or work emails to try to find responsive documents. The only time that we can meet, I'll say only in quotes, there may be, this is the main exception. The only time we can meet in private, meaning just consortium members, consortium staff, and myself, is in executive session. Most of the time, that's to receive legal advice from me. We don't hold this in executive session because I think it's largely common knowledge how open meetings law works. Were we to get into very specific discussions, I might suggest we go into an executive session. There are requirements about how we go into executive session. We only have 12 participants here, which means we don't have a quorum. We actually need 2/3 of the consortium members present and voting in favor of going into an executive session to go into an executive session. So even if we wanted to go into executive session today, we couldn't. Um, just my attendance in the executive session does not make it okay. It's really for me to give you legal advice and for you to ask questions about that legal advice. You can't make decisions in an executive session. You can't vote in an executive session. Your decision making has to happen in open session. So we need to leave executive session and come back into the public session to make a decision. This is a little more detail on how it exactly works. It's rare for the consortium to need to go into executive session. You don't need to memorize this or anything. I'll be there if we want to go into executive session or if we've had one scheduled. I'll control the process and get us into executive session. Here's how it works if we violate open meetings law. We can correct it by whatever decision was made in violation of open meetings law. We can go in if that happens, and hopefully doesn't. We can go back into public session and still make that decision and correct it. The biggest concern is probably attorneys' fees and costs here, the prevailing party. If someone asserts a violation of open meetings law and we litigate it and they prevail, they get their attorney's fees and costs, which can be pretty high if we go all the way to a final decision. Maybe most importantly for your purposes, you would have to disclose the content of your conversation that violated open meetings law were you to have a problem. All right, that is open meetings law. I realize I went through it pretty quickly. The big thing that I want you to get out of this presentation is really that these things exist. So you have a little light in the back of your head that goes off just enough for you to know to give me a call if you have a concern about something. But I will stop here for any questions that you might have about open meetings law or executive session. Hope.
I just wanted to comment for the consortium members that haven't experienced this yet. A lot of times consortium members will go to, we'll say, a conference where they are talking about produced water. It's tangential to the Colorado Produced Water Consortium's business. And what we do is either the member will tell me and I'll include it in my update at the beginning of the meeting, or we'll do member updates where the member will say, I went to this conference and multiple consortium members were there, and this is what we talked about. So that is one way where we increase transparency of the consortium's work.
Fantastic chime in, Hope. The general cure for anything like this is just to disclose it. And the scenario that Hope just described is a common one. Um, the best practice is if when you run across a consortium member and you weren't expecting it and you happen to have a conversation and you've got any concern at all, can't go back in time, but you can at the next consortium meeting say, hey, I ran into consortium member X and we had a little conversation about this. It wasn't planned in advance. But if that happens, please give me a call and we'll work through how to respond to that. But generally, just disclosing it at the next consortium meeting covers our bases. Colorado Open Records Act, I think we're all aware of this. Just generally, I just want you to know that the documents that you create and in your work as a member of the consortium are subject to Cora requests. And so you should be aware of that in your communications and even in things like your notes. There are exceptions to Cora. Some things you can keep private and away from disclosure, but our general advice to all of our clients at the Attorney General's office is don't ever plan on relying on an exception. So just be aware that the emails that you send, the text messages that you send, the documents that you create in your work as a member of the consortium are all subject to Cora requests. I don't believe the consortium has ever gotten a Cora request. Okay. Not that that's a reason to not be careful about this, but just so you're aware, I don't believe the consortium's ever gotten a Cora request. What is a public record? This is the legal definition. And fundamentally, it comes down to what I just said. If it's created as part of your work as a consortium member, emails, text messages, documents, whatever they are, it is subject to Cora. And that even if you use your personal email accounts to send that email, that does not make your entire account suddenly public, but sending it on a personal email account does not save it from being subject to Cora. There are a number of exemptions to Cora. That means even though that document may fall under the definition of a public document, it still does not have to be produced pursuant to a request. Certainly, attorney-client communications, there are a wide variety of confidential documents under state and federal law. The big thing I want you to be aware of is this last bullet. That narrowly construed generally means courts do not love exceptions to Cora, and so they keep these pretty narrow in terms of the categories of documents that fit into these exemptions, which is why I said earlier, please don't assume that something you created as a consortium member will be covered under one of these exceptions. Okay, so that covers the Colorado Open Records Act. Are there any questions about Cora? Okay. Now we're going to talk very briefly about conflicts of interest. You, as a member of the consortium, are subject to the statutory Colorado Code of Ethics, meaning you should not participate in a consortium decision if it creates a conflict of interest. And we don't have time, and I don't think there's a reason to go through all of the various ways a conflict of interest could rise. What I will say is briefly, it's mostly financial. If you or a family member could benefit personally, financially, as a result of a consortium decision, and you think that's a possibility, give me a call. I do not mean that your employer, your company could benefit from a consortium decision. That's not what we're talking about. We're talking about a very personal to you financial benefit. That's most of the time where conflicts arise. However, that being said, the appearance of a conflict is almost as problematic as the actual conflict. So if you were to ever come across a situation where you are wondering, should I be participating in this particular vote? Give me a call. Um, as I say in this particular slide, most of the time, all you really need to do is say, hey, I know this person. We went to college together or whatever. It's not going to affect my ability to be impartial here. And that will cover our bases. Um, you are subject to what we refer to as the gift ban. There's a Colorado constitutional provision that says that, as it says on this slide, prohibits government employees and members of boards and commissions from receiving things of value. I think the reason for that is probably pretty obvious. Um, so this covers pretty wide variety. It only applies to you in your work as a consortium member. Uh, the things that you go to as a consortium as a whole, so like next week, have already been vetted for problems with the gift ban and been okayed. This might arise, if somebody calls you up and says, "Hey, I want to take you to lunch and talk about the consortium," and I'll spring for it. My general advice is don't let them spring for it. Pay your own way on that lunch. If you have any questions about this, again, all I want to do is put that little light in the back of your brain that flashes when something like that you should call me about comes up. Give me a call if somebody wants to take you to lunch or wants to fly you somewhere to participate in a conference as through your work as a consortium member. This does not apply to your day-to-day job. You do not have to all of a sudden stop letting people take you out to lunch if all you're doing is talking about your day job or it's for your employment. This only applies to your work as a consortium member. This is a little more detail on kind of the ethical duty that you have as a consortium member. This is where the direct economic benefit comes in. Again, you may be making recommendations as a consortium member that could benefit the company that you work for. That's not a problem under the code of ethics. We're talking about a direct economic benefit to you as a result that may raise a conflict of interest. Again, the appearance of a conflict or impropriety is as important as avoiding that is as important as an actual conflict. All right, I'm going to skip ahead real quick. I think we're about done. These rules of order about how the consortium operates, we have to have a majority of the consortium present. I think that's 30. I can't remember. I'll double check that before next week. I can't remember the
Well,
exact
we
number.
have 31 members, so we
Right.
typically do
I think it's
16 as
16.
our
Right.
quorum.
Okay. So 16 people have to be present on the consortium for the consortium to take any formal action. After that, of those six, let's just say we only have 16 people. After that, then a majority of those 16 people have to vote in favor of a motion or something for that motion to pass, which means we don't have to have, if only 16 consortium members are present at a meeting, we don't have to have all 16 consortium members vote in favor of something. It just has to be a 9-7 vote for a motion to pass. Um, Everybody has equal rights, privileges, and obligations. Our practice is when you would like to speak, whether we're in person or remote, raise your hand, however it's raised, and please wait until the chair recognizes you to speak. Our chairman is John Messner. He he's been doing this for a long time. He knows what he's doing. He will recognize you and then you can speak. That's really just to avoid a very messy record with people talking over each other. And so we ensure that the public is able to understand who's talking and what they're saying.
Kyle, can
Motions,
I add something there?
please.
So for the consortium members who haven't attended a meeting yet, we don't really make motions. We're not that kind of formal board or commission. We don't have any regulatory authority. And we generally work on consensus. If we cannot reach consensus, we are required to capture everyone's voice. So it's not, we don't really work on a majority. So if we have discussions and only one person is like, you didn't capture my voice, I will, it's usually reports that we produce. In the report, I will capture that specific person's point of view.
Thanks, Hope. Last slide, last substantive slide. I think public comment. The consortium does allow for public comment at meetings, as most state public bodies do, I think. The consortium, and this is largely done, I think, through our chairman and Hope handles our public comment. We can control the length of time that a public commenter has to make a comment. We can also control generally that please speak about consortium business. We can't necessarily, we cannot control content to the extent that we can't say only, you are only allowed to comment if you say nice things. That's called content control or subject matter control. It's a free speech issue. If you allow public comment, and we do, you're going to have to sit through some negative public comment sometimes. That is just the way it works. All right, last slide. This is my name again, contact phone number, contact email. Please do not hesitate to reach out if you have questions about any portion of this presentation or something comes up in the future. And true to my word, it's 11 o'clock, so I think it was a half an hour. Please remember this the next time I spend a long time saying something that I actually did has brevity at times.
So Kyle, we actually had an hour, but I think it would be fine because I don't think any members of the public would be coming right now.
Okay,
But
I'm going to stop sharing. I'm happy to send this presentation out to you all so you have it. I think, Hope, is it available already in a different format? This presentation, all I really did, Hope, was change the year on the first slide. I somewhere is the presentation I gave the first time I think it was 2023, and very little has changed.
well, you actually gave one last year as well. But
Oh, right.
so this will be the third training for the consortium. And if you send the slides to me, I just post them on the website. As
Okay.
with all of our documents are posted on the website, I try to be as transparent as possible with the public and make all of our work available on the website. And they can contact me and I'll provide whatever they're requesting for. I haven't received any core request, and I hope it is due to the transparency that I try to have at every meeting. But that's so. Thank you, Kyle, for our training. You'll send me the slides. I'll put them on the website. I will also send a follow up to the new members and the current members about this meeting because it is a required meeting. You will be offered a stipend or per diem for attending this meeting. And so I'll be asking you if you would like that or not. So thank you, Kyle. Thank you, Jesse, David, Matt, and Mariella. I really appreciate you coming to this training. I know it's time out of your day, and I hope to see all of you in Trinidad, either online or in person.
Great, thank you.
See everybody next week. Thank you.
Thanks, Kyle.